Good afternoon, and welcome to the Appellate Division First Department. Most of you are familiar with our beginning shtick. We are familiar with the briefs, the record, sometimes more than you wish we were. So please understand that I right now have 5.5 hours of requested argument time. And I can assure you that the people at the end of the calendar don't want to wait that long. So I'm going to ask you to ask for that time that you actually need, not the time that you want, understanding that the clock is for you, not for the members of my court. So if my colleagues, because your questions are so brilliant, decide to continue asking questions, I will let it go, okay? So don't despair if I cut your requested argument time. As I said, if you're brilliant, you can keep on talking. All right. First case on the calendar, People versus Sammy Ayala. Good start, submitted. Mann versus Mizuyan. Okay. 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 2 and 2, 3 and 3. F. Quayim. Okay. Well, it seems you've scared off the appellants. Would you like to submit? Yes? Great. Have a seat until the rest of the calendar is called, and then you can exit. Bodner versus Floral Associates.
Respondent, 2 minutes.
2 and 2 and 2?
Additional 2 minutes.
All right, 2 and 2 and 2 and 2. All right. Jerez versus 2400 Amsterdam. Okay. Okay. 3 minutes. Okay. You said 2 and what?
I'll see my time for a while.
Okay. All right, and you said 3 minutes. All right, 3, 1, 2, and 3. List versus Lancaster. Okay.
Your Honor, for respondents and cross appellants, I'm asking for 12 and 2.
Okay, 4 and 1 and 4 and 1. Rosen versus Zionist Organization.
4 the appellant, 3.
Okay.
For respondent, 5. I'm sorry,
3, 3, and 6. Studio V 1872 versus Advanced Retail.
For the appellant, studio, 3 and 2.
Okay.
For the respondent,
3 and 2 and 3. People versus Eugene Miller. Okay. 6 and 1 and 6. RREF 3 Storage versus Paul. Good afternoon.
On behalf of appellant, 5 and 2.
Okay.
On behalf of respondent, 5, please.
5 and 2 and 5. Sonar Scene versus 84 Lumbar Company. Okay.
Respondent, 5, please.
All right, let's do 7 and 2 and 5. People versus John Rosado. Submit. Riverside Center versus Lexington Insurance is a submit. Chua versus Trimline High Tech is a submit. First case on the calendar, People versus Sammy Ayala. Oh, sorry, I didn't read my note properly. I read it as a 3 instead of a submit. Mann versus Mizuyan. Thank you. Hi. Give me 1 second. Let me get your time. You may proceed.
Good afternoon, Your Honors. May it please the Court. My name is Travis Wong for Plaintiff Appellant. We have one issue before the court today.
Okay.
Whether Industrial Code 4.2K is sufficiently specific to support a Labor Law 241-6 claim. It is our position that it is. Based on the plain language of the code, it sets forth a specific mandate.
Well, we are familiar with it. Now, part of the problem I know that you have is that Judge Manzanet and I were not too long ago on a case that found the other way, and that seems to be the way the law is in the First Department right now. So what can we do about that?
I mean, I understand that. If the First Department originally found that it was sufficiently specific, that has changed since then.
That's
And I
true.
think based upon an analysis of the language, it does set forth a very specific conduct for defendants to protect workers from a specific danger that arises from excavation machines.
Well, Counsel, the Fourth Department recently reviewed this same issue, and they found in the same vein as the First Department, the Second Department seems to be the outlier.
Yes, the Second Department has found it. And again, this is going to be based on a analysis of the language. I believe that
Which you obviously understand we did twice before, right?
before,
So,
yes, and once again before and found it in the opposite. So there's obviously a division between the departments at this point in time. And I think that it's, just logically, it is hard to understand how a plaintiff who gets injured by an excavation machine has no legal recourse when there is a code that sets forth specific conduct to protect workers from the danger that he
So counsel,
injured
not
from.
to re-argue a case that's already been decided, right? But if you look at the language of the code section that you're referring to, it is so general that I don't see where it provides any specific guidance. Persons shall not be suffered or permitted to work in any area where they may be struck or endangered by any excavation equipment or any material being dislodged or by falling equipment. What does that really say? Where is the guidance for the construction manager or the owner or anyone?
And I would just disagree with you there because if this is only in areas where they may be struck by excavation equipment or the materials that are lifting. These are giant machines that are in a specific area. It's not the entire construction site. It's only those areas around in which workers should not be allowed to work because of the increased danger that those machines present.
thank you. You'll have time on rebuttal.
Good afternoon. May it please the court, my name is Lauren Donnelly, and I represent the defendant respondent. As this court has consistently held, 23-4.2K is not sufficiently specific to support a labor law
Let
241-6.
me ask you two things. I mean, at one point, way back when, we did actually go the other way, and that has changed. But are there other industrial code provisions that this plaintiff may rely on based on this accident as it occurred, or is this his only chance at any recovery?
I am not aware of that. The only issue we briefed was this particular, and my apologies for not knowing the answer to that question. But it doesn't matter because Labor Law 241-6 requires a concrete, specific command. This, if you look at the language.
Counsel indicated this only says that, you have to be careful when you're near an excavation machine, and that's a large machine, and they're not all over the construction area. There's a limited area, so why would that not take it out of the too general?
Well, the courts across New York State, even the Court of Appeals have said the language suffered and permitted is too broad. Area and endangered is also too broad. This is really just a general workplace statute. What should happen is an industrial code provision with specific commands should be enacted in order to prevent or to accomplish the goal the plaintiff is saying here. But in terms of this case, it's stare decisis. This court has held it. It's been consistent for 20 years. It is the evidence
Is
that
there,
it's the
is
correct
there
law.
anything, that there's this conflict now between the departments, honestly, with the second department's ruling, and where do we go from there? Maybe this is something that should be decided by the Court of Appeals.
I believe in the case Sparendham, they sought leave to appeal to the Court of Appeals, and it was denied. So I think the Court of Appeals has really sided with this department, the third and fourth department, without expressly saying so. So unless there's any questions, I'll let my colleague take the floor.
Thank you.
Good afternoon. May it please the court. I'm Richard Ashnault. I'm here for third-party defendant respondent Mayrich Construction. The real problem here, as far as I see it, is the provision that is argued to be specific could apply to any danger posed by any excavation equipment in any area. It's not limited to areas where big excavation machines are being used. It's not limited to big excavation machines. It's not limited to being struck by such equipment. What constitutes excavation equipment? What is included in any excavation equipment? A shovel?
Counsel, I'll ask you the question that's been asked already, but not of you. Is there any provision in the industrial code that pertains to excavation equipment?
I know that there is one, and I can't think of it off the top of my head, that deals, it is essentially, it applies to authorized people being not allowed to work in areas where excavation is ongoing. So the question is whether this person was authorized to or not. I mean, arguably, the equipment that the plaintiff himself was in the process of repairing at the time, the drill that was being repaired is a piece of excavation equipment. If he is standing next to the mechanic who is,
I wouldn't call a drill a piece of excavation equipment.
it's being used by him during excavation
The
operations.
fact that he's using it doesn't make it a piece of excavation equipment.
Okay, well,
I mean, to excavate means to dig out, right?
okay, well, that's what he's doing. He's drilling holes to dig out the material in order to put explosives in where the excavation is going on.
Well,
So,
he's drilling for the purpose of furthering the excavation work. Then
well,
perhaps,
that-
maybe, whatever.
I think this conversation that we're having underscores part of the problem with the provision that we're talking about here.
Does the provision at all kind of provide measurements? Like if you're using an excavation backhoe, there should be no persons within a 20-foot radius of the backhoe because that's the arm's extension, for instance. Is there any kind of provision that gives us those kind of specifics so that it would fall outside of a general provision?
Within the provision that we're talking about today, no,
Right.
there is not. Again, I will, at the risk of repeating myself, any danger posed by any excavation equipment in any area.
Thank you.
Thank you.
All right. You have 2 minutes.
Thank you, Your Honors. I would just say,
So look, I recognize clearly workers inside a excavation hole where there is a huge excavation piece of equipment that continues to dig creates a potential hazard to people. But as I described to your adversary, it seems to me that if we want to say that it is specific enough, it should at least account for the span of danger, the zone of danger, for lack of a better word, right? Of how far out does a construction manager have to concern themselves? Because otherwise, who can work in the hole other than one person at a time?
I mean, I would just disagree with that statement. All the The code requires defendants to take steps to ensure that workers are not working in areas where they can be struck by the excavation machines. All that requires is that excavation machines work in one area and workers work in another, and workers are not permitted to work in those areas in which the excavation machines are moving or moving materials.
So again, you made a circular motion with your hand, which to me says that there should be some sign, some declaration of what the zone of safety of that equipment is. Do any of the codes provide construction developers with guidance on what that is?
There's no specific zone of safety, but I believe it is up to the construction, the managers, the safety people, to determine what is the area in which someone is not at the risk of being struck by these excavation machines or materials that they're carrying.
In other parts of the industrial code, though, those kind of radius, that is actually delineated, right? And the fact that it's not here, maybe that's why we can interpret it as being very general.
In some, but I would say there are some other codes that are, which I believe are in my brief, that have been found to be sufficiently specific, that do not have those specific zones or numbers.
Okay.
And I will
Thank you.
rest on my paper.
Sounds like this one's going up to the Court of Appeals.
Yeah. Thank you very much.
Thank you. All right. Bodner versus Floral Associates.
Good afternoon. May it please the court. My name is Nathan First. I represent the plaintiff appellant, Alan Bodner. As the court has thoroughly reviewed the briefs and the record, it was simply to state that the prime issue before this court, in my view, is whether or not the court below was in error to say that the utterance and the publication complained of fit into the litigation exception to defamation.
Why doesn't it?
I'm sorry, Your Honor?
Why doesn't it?
Because
it related to?
it did not. If I
Okay.
may respectfully differ with the court. The action below had to do with a claim by Mr. Bodner's client that the defendant entity, had failed to account and turn over monies arising out of a substantial sale in a real estate transaction. The lawsuit below had to do with whether or not that had happened, and if so, how much was owed by the defendant below to the plaintiff. That was the issue.
But there were also counterclaims in that
There were
lawsuit.
counterclaims, but at no point in the proceedings below, whether in the pleadings or in the affidavits, did the question ever arise in any way, shape, or form that there had been theft, let's use the brutal word, of the proceeds for the benefit of the sellers.
Didn't the counterclaims allege to an extent that the monies were potentially not turned over appropriately? I mean, wasn't that part of the discussion? It seemed to me it was.
Yes.
The counterclaims had to do,
Yes, absolutely yes. So I'm trying to figure out how you take the position that this had nothing to do with it.
because Mr. Bodner was not a party. Mr. Bodner was the lawyer.
So what?
Mr. Bodner was,
Was Mr. Botner directly the one named? I don't recall that the statements made by the defendants here directly said anything about Mr. Bodner by name. Am I correct?
They said the attorney. There was only one attorney. Everyone knew that Mr. Bodner was the attorney and he was the only attorney. And therefore, any counterclaims that they might have made against someone else had nothing to do with Mr. Bodner, who was specifically alluded to. There is no doubt, reading this record, that the defamatory comments had to do specifically with Mr. Bodner and only with Mr. Bodner. That cannot be denied.
Is the only way that, so it seems to me that your position is that any claim that monies following some transaction that have to be dispersed to various parties of interest, if there's any error in the way that that gets dispersed and you claim that error, you're calling me a thief. Not that you're mistaken, not that there was something, whatever.
I
The
don't,
only way is that I am saying you're a thief.
isn't that what it says?
No,
Did they
No.
say mistake?
no, that's not what
Is
what
the
I believe
import
it
of the,
says.
is the import?
And sir, with all due respect to you, you don't get to ask questions back to the court. That's not how this works.
It was rhetorical and not intended to be disrespectful. I believe that a fair reading of the utterance and the publication is that Mr. Bodnar behaved dishonestly, that he misdirected the monies. It
Is he
doesn't
the,
say-
is Mr. Bodnar the only person who dictated what happened in that case? I believe Mr. Bodnar had a client, right?
Of course.
And so sometimes a client will tell an attorney to do something that an attorney may say, I don't think that's well advised, but you're the client, I'm going to do what you say.
Of course
Does
that,
that happen?
it happens all of the time.
Okay. You'll have time on rebuttal.
May it please the court. My name is Michael Schoenberg. I'm an attorney at Ruskin Moscow Faltachek.
Did you allege Mr. Bodnar was a thief?
Absolutely not, Your Honor.
Tell me why that is not the case.
First of all, the statement that's the subject of the defamation claim doesn't even mention Mr. Bodnar. It mentions an attorney. There was no way from that
He
statement.
says Mr. Bodnar was the only attorney, so we all know who you were talking about. Why is that not correct?
In an underlying corporate transaction where there was a private sale of property, there was no way of knowing who that attorney was, and that's what that statement refers to. Yes, Mr. Bodnar was the only attorney representing Melrose in the subsequent litigation, but to infer that the litigation counsel was also the transaction counsel is an implication that's not found from the statement.
From the transaction, were there any documents signed by the attorney that would have revealed that Mr. Bodnar was the only one?
Frankly, Your Honor, I don't know the answer to that question because it was a fairly large transaction. My understanding is, though, there was a private transaction, and if one would need to do significant due diligence to connect those two dots, if that were the case.
Counsel-
That's not from the face of the statement.
That sounds like you didn't answer my question, is what it sounds like, okay? Don't tell me that you didn't look at not one document for this transaction and didn't find his name on it.
I believe that his name was on those
Okay, so
transaction
did you find another attorney's name on any of the documents that you did review that would support your position that you weren't sure which was the lawyer on the underlying transaction?
Well, again, we're looking at the face of the statement that is alleged to be defamatory, and from that statement alone, there was
You
no way.
understand I'm testing the boundaries, right? This ain't
I
personal,
understand.
because I always get blamed for being not nice. But I'm trying to test the boundaries of your argument. So tell me, what other documents showed me that there was anybody else that might have, so because his claim is that I was the only one. So when you say the attorney and you throw that term out there, we all know you're talking about me. Why is that not the case?
The fact that you have to ask what documents there were means that you have to connect the dots between the statement and who that person was from a private transaction. And because you have to make that implication, that inference, you have to go to other documents to figure out who this person is. Means that it wasn't of and concerning Mr. Bodnar. Could have been of and concerning anybody.
Okay,
I'm sorry, Your Honor had a question?
I'll allow,
May I?
absolutely.
So I'm looking at the two statements that refer to counsel. One concerns that the general partner, ESCM, and/or their counsel has not properly distributed the funds, and at P, Melrose and ECM and their counsel may have participated in a failure to distribute the funds. Is there any place that elaborates in the record as to what impropriety was committed by counsel, if any?
Your Honor's question raises an interesting response to it. The short answer is no. But again, the question was asked in discovery in connection with the litigation as part of an investigation to substantiate the counterclaims. That's where all these questions come in. It was an attorney doing their job, being a zealous advocate for their client, and that's the source of those statements.
Thank you.
There's
Thank
nothing
you.
further. Thank you.
May proceed.
May it please the court, John Wade of Fox Rothschild on behalf of the Floral defendants. I think everyone here knows what the key issue is before the court, which is whether or not this statement was covered by the litigation privilege. And it seems abundantly clear from all of the cases that have been cited in my co-defendant's brief, starting with the Court of Appeals more than 100 years ago, being reaffirmed and further revised by the First Department, that it absolutely is a discovery. It's a discovery dispute in which the statements are clearly privileged because the standard is.
So you would define this as an absolute litigation privilege, correct? Because as long as it has anything to do with the claims in the litigation, then it falls within that privilege. Is that your position?
That's our position, Judge, particularly in looking at the language of the cases that say things such as, if it is at all pertinent, which is the Latcher case from the First Department, which in turn cites the Humans case from the Court of Appeals, that's on page 14 of the brief. Anything that may possibly be pertinent. There's the Martirano case from the Court of Appeals. Cases go on to say no matter how false or injurious, it's still covered by the
I'm
privilege.
glad you said that because the statement doesn't have to be proven to be true, just related,
Just
arguably related.
Just related, that's correct.
So taking the discussion in a slightly different, to a slightly different place, with respect to publication, the plaintiff alleged that the so-called defamatory remarks were made to the judge, to court personnel, and to those interested in this action. So my first question is, outside of the litigation, were these statements made to anyone else? And if not, is that a defense or does that help you?
Well, the statement was made in an email. The email was submitted to the court. That court submission is a matter of public record, but the statement was not made outside that. So the extent to which it went beyond the court is only to the extent which it was on the docket.
Thank you.
Thank you.
All right. You have 2 minutes on rebuttal.
It won't take that long.
All right.
It's our position that the exact wording that's at issue is intended to damage and demean Mr. Bodner. It's our position that it is not privileged to go against the lawyer, and they knew in that litigation, they knew at all times in that litigation that Mr. Bodner had been the transactional attorney. So there's no question that this pertained to and was directed at Mr. Bodner.
But counsel, we would agree, wouldn't we, that a lot of times things are said in complaints that are inflated, overstated,
But this wasn't said in-
excessive? Do you not see this in the same vein?
I do not. I agree with the court completely that things are said in complaints, things are said in pleadings, things are said in affidavits, but they have to be at issue. They have to pertain to the underlying issues. These statements are a fishing expedition that seek to expose Mr. Bodner to ridicule and to injure him by saying, this guy stole the money. That is a fair reading, and that is our position. And
The
that,
Court of Appeals has said to be actionable, a statement made in the course of judicial proceedings must be so outrageously out of context as to permit one to conclude from the mere fact that the statement was uttered that it was motivated by no desire other than to defame. And that's tough to get to. So that's what you feel is what happened in this case?
yes, and I feel further, Your Honor, that the only way to establish that at trial is for the complaint to be reinstated, for discovery to be had, to demonstrate that that indeed was the motivating factor here. I believe that this language gives rise to that inference, and I believe that that can readily be demonstrated if the case is reinstated. And I believe that that is a question of fact which has to be adjudicated below.
Thank you.
Thank you.
It is versus 2400 Amsterdam. You may proceed.
Thank you, Ms. Loveless. Good afternoon, Your Honors. Greg Friedman, we have the plaintiff appellant here. Arguments aren't complicated. We've all read the record. We know there's plenty of evidence suggesting that plaintiff fell in front of this Moya store, which is at 2404, but she also identified the spot she tripped on to other photos. I think they're 726 and 729 of the record. And then another witness who's lived in the building for decades looked at the same photo and he said, that's the property line between 2404 and 2406.
It was Mr. Cortez that said it?
Exactly,
And
right.
he pointed out, I mean, I was looking at a lot of pictures here, but he seemed to be pointing out a white line in, I guess, the flags were not.
Correct. It was basically the exact spot where the flags meet and are uneven. So we obviously have an inconsistency. Like you said, we have a lot of photos. There are different times at different angles. And I think the only real question is, well, you have conflicting testimony. Are we prepared to discard some of that testimony as a matter of law? I don't think.
How do you do that? How do you disregard and discard testimony as a matter of law?
Well, I think that's our argument. We can't do that.
Right.
Right. I don't think we can. I'll be the first to admit, because it's right in the record, that there are some photos that suggest she fell in one spot. There were photos suggesting
And
she
so
fell
why
in another
does that not create an issue of fact here?
It does.
Where this deposition was held virtually. These photographs are being marked virtually. She's testifying through a Spanish-speaking interpreter, which already creates all kinds of problems with respect to negative questions that are not easily translatable.
Your Honor, I think you just cut out about 2 minutes of my remaining argument.
Wonderful. Then I'm
was
doing a
going-
great job. Go ahead.
But now I'm going to repeat it because I feel like I have to take some credit here. Put this into context. As the interpreter, she has photos from every which way, and what we have are the attorneys moving a mouse cursor around trying to say, is it here, is it here? Realistically, this would have been much better if it were done in person. There were questions that could have been asked but weren't, but we have the record we have. And when you give the plaintiff all the favorable inferences, I don't need to remind anybody of that.
Let the jury figure it out, right? Or-
Exactly. There's plenty defendant has to work with here, but they have to do that at trial, not summary judgment. Because you made my job easy for me, I'm happy to sit down if you have other questions.
Great.
Thank you.
You only have 15 seconds anyway, but it's okay. It's the first one. Next.
Your
You
Honor,
may proceed.
please the court, co-appellant for 2400. I will not repeat everything that my colleague just said. Our papers are nearly identical. I will merely reiterate that certainly cases exist where there are non-material issues, but when we have testimony that says one thing, oh, it's here, testimony that says another thing, a lot of times, you know, judges want to make things simple. I want to make things simple, and maybe a jury will agree with 2406. But the fact of the matter is, we have two different pieces of testimony, and because of the problems that COVID has created with virtual depositions, moving cursors, it creates a host of problems, and the facts here just are what they are. I think in our reply papers, we also mention that there actually wasn't even an establishment, and I'm saying this at the risk of opening myself up to attack for issues that might not be before the court, but we never even had an establishment in the underlying motion papers of where those property lines truly were. We all were operating on assumptions of awnings equal property lines and storefronts equal property lines. Well, we live in New York where there could be 8 storefronts between property lines. We don't know. None of that was even established in the underlying motion. And I think there were a lot of assumptions made by the lower court along those lines that are really problematic to decide this as a matter of law.
Thank you.
Good afternoon, Brian Dalton for Respondent 2406.
So, counsel, to the extent that everything was done virtually, I know that looking at the photographs myself on a large monitor, I had difficulty figuring out what was where. Why shouldn't this go to a jury?
Your Honor, first of all, because there is no conflict. The plaintiff never identified an area where she fell. She said that condition looked like it. The photograph that they're trying to raise an issue of fact was a close-up of a sidewalk with no perspective to the various storefronts. The plaintiff was
But why
clear,
doesn't that in of itself raise an issue of fact? I mean, how does that determine anything here?
because I think a photograph where the plaintiff herself simply said it looks like it can't overdo the overwhelming evidence. And by the way, before I was in the case...
What overwhelming evidence?
yeah.
Don't move on. What
No,
overwhelming
yeah,
evidence?
First of all, after I came into the case, I took pictures that showed all the buildings, all the awnings. They never showed her to that. The first one was just this sidewalk thing. The overwhelming evidence is the testimony. She was walking in the middle of the sidewalk. The testimony that she landed in front of the liquor store, uncontested by anyone.
That doesn't, but she said that she took several steps as, you know, when you hit your toe against a sidewalk flag that makes you trip, most people don't just drop on the spot right there. They stumble forward, and that's what she described, that she stumbled forward and fell in front of the liquor store. So there's the spot where she fell, and then there's the spot where she tripped.
Right, and she identified it as I tripped in front of Moya. She described the awning.
Moya is the liquor store.
No.
No?
The liquor store is the second store beyond that.
Okay.
Further south. She marked the photograph with the cursor, and there was no trouble at the depositions. I mean, I understand there's problems. Well, there was like 5 attorneys there. I mean, we
And
got
no
it done.
trouble at all. No, not at all.
No, she marked the photo clearly. There's no objections on the record about how it was marked. She fell in front of the liquor store. She had mental notes of the various buildings and the stores. She made it clear about the liquor store and Moya when she was shown good photographs. And then at the last step, they showed her this again, sidewalk near the street. By the way, she said she was walking in the middle of the sidewalk. And they show her this close-up, and she goes, yeah, something like that. And that's their question of fact. I submit it's pure speculation. It was clear the plaintiff herself didn't know what the defect looked like. It was when the ambulance showed up a half hour after the accident.
There's
that the-
nothing wrong with that, though. We have plenty of cases that say someone falls, they don't know what made them fall, and later they discern what made them fall. That's enough. If they observe what they later can attest, that's what I tripped on.
Okay, but Your Honor, she didn't testify, oh yeah, this is the sidewalk flag zone. It was in front of this building. And quite frankly, it was right on the street. It could have been any flagstone, broken flag. And I think it's close, you have to get into the plaintiff's mind, was she speculating? She didn't clearly identify it, she didn't mark it, and all the other testimony was what I said. One other thing, Your Honor, there's a photograph in the record, shows a woman with a mask, a face mask, walking right in front of Moya. Testimony about that is clear also. She said, oh no, I fell south of that woman, or further away from my client.
Okay,
So,
thank you.
thank you, Your Honor. Bye-bye.
I know I reserved a minute. I shouldn't need that long. Number one, very short. I believe it's a 189 of the record. This is when plaintiff shown Exhibit G, the photo, and she says, the spot where the sidewalk is protruding, yes, that's what I tripped over. So she identified where she fell. The only other thing I'll say is, I'm going to harp on a word that my adversary used when he was up here. He said, overwhelming evidence, 2-3 times. That's a very nice argument you made for trial. We're not dealing with strength. We're not dealing with credibility. This is summary judgment. And I think everybody recognizes that here. If there are any questions, I'm happy to answer. If not, I'll rest on the brief.
Thank you so much.
Thank you.
List versus Lancaster. You both have 4 and 1. You may proceed.
Thank you. May it please the court, Nicole Sullivan from White and Williams for the appellant, defendants, counterclaim plaintiffs. The lower court's order denying respondent's 3126 motion to strike our pleadings should be affirmed, and the court's order under Rule 130 that it issued sua sponte should be reversed in its entirety. This case involves discovery issues. We produced thousands of pages of discovery, and at issue in this sanctions order was 6 documents that the court ultimately held we should have produced and that we didn't produce. The 6 documents were actually contain communications internal at a law firm that had been advising the appellant on the business relationship between himself and the respondent, and they support the contemporaneously support our allegations here.
Are you positing that the material in those communications, or the content rather, of those communications had nothing to do, was in no way relevant to the request, to the discovery request?
So there's a difference between the discovery requests that were served on the parties during the discovery, and then, you know, discovery got convoluted and we had to go to a special referee because we couldn't reach anything without the court's intervention. There was a recommendation based on the report and recommendation, which was confirmed by the court. We do believe that we had complied with that. The only documents that they're at our issue were these internal communications where they were doing scheduling, or it was the actual initial referral of the client to the law firm. And then,
Are you answering my question? Is it your position that the content was irrelevant?
I think the content, I think that we didn't produce the content because it wasn't responsive to the order that we had at the time. If you're asking if the attorney internal communications are relevant to the business relationship issue, the answer is yes. I mean, the court found that, but ultimately we had a good faith basis not to produce those documents. We were limited to producing in the report and recommendation the documents and communications that were between Mr. Lancaster, JAL, Texas, and the law firm, which is what we did produce. The documents at issue here were, like I said, a scheduling notice, and they actually support our case. So they show that we intend.
Help me with this a second.
Sure.
So information that says, well, first of all, the issue is whether there was a partnership or whether there was an employer-employee relationship, right? That's the big question.
That's one of the big issues, yes, Your Honor.
So content that says starting company together and that says clear from beginning profit sharing, your position is that was immaterial and irrelevant and it had nothing to do with the request at hand or the directive?
No, my position is that those are the handwritten notes and mental impressions of the counsel that was advising Mr. Lancaster and his company at the time, and that we weren't ordered to produce those. They may have been responsive to the discovery requests, but they weren't ordered. And then when he issued the subpoena,
I don't understand the distinction between responsive to the discovery request and not
because the documents were work product. They're the attorney's
So did you
mental
declare
impressions.
that? Because typically when there's a document that is relevant, but that a party considers work product, they put that on a list of items that they intend not to disclose and the reasons, what privilege
No, we understand
guards
that.
them. So why wasn't that done here? And I gotta tell you that your earlier comment that this document actually helped us flies in the face of non-disclosure, because if it helps you, why not turn it over?
It's a fair question. So I can't speak to exactly why it wasn't put on the privilege log. It was not put on the privilege log. Should it have been? The court found it was. Yes, it should have been. I'm not trying to walk away from that. The
Right.
question here really is, does the failure to put it on a privilege log and withholding these 6 documents that actually confirm the same allegations that we pled in our answer and counterclaims warrant a sanctions order under Rule 130, which had not been noticed by the respondent? We didn't have an opportunity to be heard on it. It was sua sponte done by the court in response to the motion to strike the answer and the counterclaim. So that's really what we're saying, is that this does, even if it was erroneous or something we should have done.
Excuse me, hi.
Sorry.
The court, when the court made its ruling, it said that they can move later for sanctions. They didn't do it all right away, correct?
So in the order on the motion to strike, she denied the motion to strike and gave him the opportunity to move for sanctions in the form of reasonable attorney's fees. That's motion sequence 12. What motion sequence 12 did didn't move under Rule 130. It just basically made a motion for reasonable attorney's fees in the amount of, I think, $35,000 and
So
change.
you're saying you didn't have an opportunity even at that time to have opposed that, since there Section 130 sanctions, you couldn't have opposed that there and said, look, maybe you found this, but we don't think you were entitled, judge, to sanction us at all because it hasn't procedurally been done right.
Yeah, we attempted to do that. We did file a motion to re-argue on that basis, and the court denied it. So that's what I'm saying. I'm not walking away from whether it could have been relevant or should have been on the log. You know, there could have been errors made on counsel's part. It's just not, I don't think it's sanctionable conduct under the standard, certainly not for striking the pleadings or frivolous conduct.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court. My name is Isan Dora Amaji for the respondents and cross appellants.
So counsel, just picking up on that last point, was there an opportunity to be heard on that sanctions issue?
Yes, there were two opportunities to be heard. The first opportunity to be heard was in the motion that was made to have the pleading struck or for other further relief as the court deems just.
So you're saying it fell within the gamut of other relief that we might seek? Is that what you're saying? The sanctions portion?
I'm saying that the conduct that was raised, that was made at issue in the motion to have the pleading struck or for such other and further relief, is the very same conduct that later the court said, well, the sanction I'm going to give you is a monetary sanction.
Right. But when you're seeking sanctions, right, there needs to be an opportunity to be heard. You're saying that general statement, I understand the conduct you're saying is going to be the same, that motion or a later motion, but wouldn't you need to specifically move for those sanctions?
I think that we moved to have a greater sanction than the one that was imposed. We moved to have their entire case thrown out. And the judge said, okay, I understand why, exactly what they did, that you think should have this case thrown out, and I think it was bad, but I'm not going to throw out their case. Instead, I'll give you something less than what you asked for. I'll give you a monetary sanction. Go ahead and make another motion, and this time put in your timesheets. And then they got their second opportunity. We accepted the court's invitation. We made a second motion that said, here's our timesheet.
I'm assuming in response to your motion to strike and to dismiss their claim for their violations, that they defended and explained why they didn't believe that they had even
Yes, Your Honor.
done any kind of violation, and certainly not a violation worthy of having their pleadings struck or their case dismissed. I would assume they said there's nothing.
They did their best. It was a motion on notice, and it was fully briefed. And then the next motion after that, in which we put in our timesheets, again, was a motion on notice that was fully briefed, in which they offered attorney affirmations, multiple affirmations, and a 20-plus page memorandum of law. They certainly did their best.
So certainly by the second time, they responded at the court's request for you to submit the motion for that sanction, that they certainly had a full opportunity to discuss why it should not.
Yes, and it's worth looking at what they put in, what they submitted the second time around. It was the same thing. It was the same thing. They didn't add anything new because we were talking about the very same conduct. So something that I think, if I have enough time, I'd like to raise with the court is something that's not highlighted in the briefs. The documents that were eventually produced by Lisco and Lewis show more than just what's highlighted in the briefs. Yes, they show what's highlighted in the briefs. They show that Lancaster withheld something that was FedEx to him, and he misrepresented that he withheld nothing important. That's highlighted in the briefs, but there's more. The documents produced by Lisco and Lewis also show a problem with Lancaster's production of his own emails. because Lisco and Lewis revealed emails that Lancaster should possess in his own email account, emails that contain the search terms Lancaster represents he used when he collected his own documents, but Lancaster left them out of his document production. So I want to point your honors to the parts of the record that show this. Now,
All right, you're out of time, so I need you to give me a summary.
well, if you look in the record at pages 240 to 241, you see an email that was eventually produced by Lisco and Lewis in native form. It's a back and forth between the Lisco and Lewis lawyer and Jason Lancaster. 4 back and forths. Lawyer to Lancaster, Lancaster replies. Lawyer to Lancaster, Lancaster replies. Some of this was produced in the first time round in the FedEx envelope from Lisco and Lewis to Lancaster's lawyers. There was in hard copy printed out 3 of those 4 emails. And the first one only of those emails was produced by Lancaster out of the FedEx envelope. They selectively produced the first one. They didn't produce the other 2 that they had gotten in the FedEx envelope. So when I took Lancaster's deposition, after I got that little bit from the FedEx envelope, and I still didn't know what else was in that FedEx envelope, and I still didn't have all the other documents that Lisco and Lewis later produced, I tried to show that one little scrap to Lancaster. And I asked him, I said, look, this is an email from the Lisco and Lewis lawyer to you, and it has the search terms that supposedly your lawyers used to collect your documents, but you never produced this from your own documents. Is this email in your email inbox right now? And my question was shut down. I was not able to ask that question. The client was instructed not to answer the question. And I'll give you the parts of the transcript where that happens. But the point is that that also connects to an earlier appeal in this case.
All right.
Wait, let me I'm sorry.
Counsel, you are out of time. Thank you.
Thank you, Your Honor.
Just briefly, this is exactly what he did to the lower court too. He's now raising new arguments that should form the basis for sanctions that weren't part of the underlying record to the court, or certainly weren't part of her order on sanctions. There's a case, from this department, the Greenpoint Savings Bank case, 208 AD 2nd 368, that says notice on 3126 is definitely not sufficient to provide notice on 130, and there was no notice on the second motion, sequence 12, that it was pursuant to Rule 130.
The judge's discussion during the sequence 11 was your notice. Don't play games.
I'm not playing games.
Sequence 11 was very clear.
No,
and the judge said after that sequence, unless you are going to tell me that what he said is incorrect, and that the record we have before us is incorrect.
I'm not saying that.
Okay, so sequence 11, the judge absolutely put you on notice about what was coming.
But the
when the judge says, you file your motion and attach your attorney's fees, ding, 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 the lights should go off.
Yeah, yes, it
Okay.
did. It did.
So that is notice.
No, but
you don't need a piece of paper with a fancy, that's notice. You've messed up, and I'm letting him move for sanctions. What more is there?
Because when we put in our opposition and our motion to re-argue, she completely disregarded it, and she didn't hear any of our arguments about the standard under Rule 130, and the actual decision didn't comply with Rule 130. You know, if you read Mr. Doramachi's reply brief—
That's why you're here. So if we agree with you, you win. If we
correct.
don't, you don't.
That's correct. If I could just make one last point, which I think is important.
I'll give you 30 seconds. I gave him 2 minutes. Go ahead.
To the sanctions question is, you know, there are, while these documents arguably are relevant and the court found that, and we're not disputing that on the appeal, there were no smoking guns here. He admits that in his paper. His smoking gun here is the FedEx delivery note that the documents were sent to us from the law firm, which we concede. But he admits in the papers on page 6 of his reply brief that that's not relevant to the merits here. So there was no smoking gun here. There really is not. Withholding 6 documents, whether properly, improperly, does not egregious conduct that should warrant a sanction.
It's not the number of documents.
No, I agree with that.
It's the materiality of those documents.
I agree with that.
Okay?
If there was materiality in any of the documents, one document could warrant sanctions. If it was a smoking gun document, I agree with that.
Right.
But what we have here are scheduling notices and the mental impressions that support the same pleadings that we had. And so that's why it shouldn't be sanctions here. Thank you.
Gotcha. Thank you. You have 1 more minute.
Thank you, Your Honor. Just
Now
quickly.
you could finish whatever you wanted to tell me earlier.
Well, I just want to give the court the citations to the record. Page 593 of the record is from the deposition where I tried to ask Mr. Lancaster about what's in his email box, and I wasn't able to ask it. If you look in the record, you will see at pages 86 to 89 and 95 to 98, the snippets of that email that were in the FedEx envelope. And if you look at pages 407 to 409, you will see the snippet of the snippet that Lancaster produced, and that I tried to ask Lancaster about at his deposition. But of course, then what later got produced in August of 2022, I was never able to ask him about because that came after his deposition was concluded. I want to also say that this is not just, I'm not just defending the lower court's decision. We have a cross appeal, and we do think that the lower court was wrong. This is a case that is serious enough that it requires a communication to litigants and to the bar, a communication like the Second Department did in the case Lucas versus Stam, which is cited in my reply brief. This case has to do with a conversation that happens all the time between lawyers and clients. I have this conversation with practically every client of mine because most of my clients are not regulars in court. Most of them are not litigating all the time. They don't know what's involved. And so they have to be told. When we find a document that may not be a document that completely destroys their case, but that is what I would call a difficult
I don't
document.
understand you. Are you arguing against yourself?
You're arguing that you think the judge should have dismissed her case, right?
Correct. I'm arguing.
I think that's a very, very severe sanction.
Yeah.
We are aware of that, and we will look at that. But I don't think from the many cases I have looked at and that we have handled here that this rises to that level. That's really, that's you
Very
couldn't
high
have a more
bar.
severe
I would
sanction.
just ask your honors to consider the conversation that lawyers have to have with their clients. When the client says, if we don't produce this, won't we never be caught? What answer is the lawyer going to give to his client? And the decision in this case will be the lawyer's answer. And if the answer is, well, we probably won't get caught, but if we do, you'll just have to pay $25,000.
Well, how we decide does not determine the proper counsel that an attorney should give their client. So regardless of what we do on this case, based on the facts and the law on this case, your obligation as counsel remains the same.
That is absolutely correct.
So, thank you. Have a great day.
Yes, thank you, Your Honor.
Rosen versus Zionist Organization of America. You may proceed.
Good afternoon, Your Honors. May it please the court. I'm Alexander Sakin for the appellant. This appeal deals with two issues. First, whether New Jersey law applies to Mr. Rosen's claims of retaliation.
And why should New Jersey law apply to that?
New Jersey law should apply both under New York choice of law and under New Jersey choice of law principles.
Where did the acts that took place pertaining to the discrimination, where did they take place?
Well, Your Honor, the discriminatory acts...
Answer the question, and then you can go on with whatever else you want to say.
Yes, Your Honor. They took place either in Georgia or Pennsylvania, because that is where the two principal defendants here who took those actions worked. They worked remotely and lived in Georgia and Pennsylvania, as far as we know.
His employment, though, was for New York, right? He prior to the pandemic, because that's when he started working more so remotely in New Jersey. But prior to that, his employment contract was for working in New York.
That's right. But then he spent 2.5 years working exclusively in New Jersey, and
So did a whole lot of people due to the pandemic, right?
So that was incidental, as opposed to where was his actual place of employment was New York.
Your Honor, this particular issue was addressed by this very court in the case of Pagniat v. Moore, and it was also addressed by the Southern District in the Schreiber versus Centerview Partners case. And in both of those cases, courts held that no matter what, no matter pandemic, if the impact of the discriminatory act is felt outside of New York law does not apply. With respect to New Jersey, the same test, essentially the same test would apply as well.
Counsel, maybe you should move on to the next point.
The next point?
Yes.
You mean the New York Not-for-Profit Corporation law? Yes. The issue of the New York Not-for-Profit Corporation Law is, in fact, the court made a decision based on CPLR 3211A1 that finding that my client, Mr. Rosen, was not, in fact, an officer of ZOA. To make that finding under the CPLR, the defendants would have had to provide evidence that utterly refutes that suggestion, and that's simply not the case here. Under the ZOA Constitution, his position of executive vice president is not listed among the listing of officers in one of the articles, and the second article, the 73A, that they cite for the proposition that he in fact was an officer is ambiguous at best and really deals with the duties and powers of the national president. Based on this record alone, it's simply at a pre-discovery stage, it simply was too premature for the court to find that he was not an officer, or that he was an officer. In fact, he was not an officer.
The Supreme Court actually relied upon a different section, didn't they not, where it said under the Constitution about making a reference to other officers and said, well, that must mean you're an other officer too. And isn't that what he or she, I think, relied upon more?
Yes, Your Honor. Article 73A is an article that deals explicitly with the powers and duties of the national president. That's what it says.
Right.
And he was not the national president. And it says, the national president, in conjunction with the chairman and the executive vice president, is responsible for the general supervision and direction of the other officers.
And from that, she to assume that would make your client an officer.
That's correct,
That was really
Your Honor.
what she relied upon.
That's correct, but it's not clear at all, because from that language, one can very easily assume that they're talking about the national president, who undoubtedly is an officer. So there's definitely ambiguity here, and certainly at the pre-discovery stage, where there's been no finding made whether my client, for instance, had the power to bind the organization, had the power to hire and fire employees, to represent the organization without permission of the national president. It just cannot be determined that he was, in fact, an officer.
Okay, you're out of time. You'll have time on rebuttal. You may proceed.
Thank you, Your Honor. May it please the court, David Picker of Spector Gadden Rosen Vinci for the defendants' respondents.
So, counsel, if we can go directly to Article 7, where the powers and the duties of the various officers are listed, and each officer has a nice big paragraph as to all those responsibilities. Why should we add the position of executive vice president that was held by the plaintiff here to be part of the officer structure of the organization if the Constitution doesn't list it in such a way?
I'd say two reasons. First of all, Article 7 on the whole speaks of officers, and the fact that this position is specifically mentioned in that article is significant. The other reason is because Article 7.3, in describing the powers of the national president, is saying that he's working in conjunction with the executive
Doesn't make him an officer. That just means that these people work with him. I mean,
Well-
it's not even as it says that the national president, and taking out that language in conjunction with, says the chairman and the executive vice president are responsible, is that still wouldn't make him an officer, because the officers are defined in the section before.
Well, the other reason, and the other reason relied upon by Justice Sattler, is that he himself alleged that he was the second senior most executive at the company.
That doesn't make him an officer.
In charge of operations at ZOA.
We all know that these things, these terms are terms of art. And the organization's own constitution defines it. Why should we add language that doesn't exist?
Well, I think that the court below, and I think this court should take the plaintiff at his word when he says he's the senior second most.
When he was, there was a pay stub attached to the motion papers, and his pay stub listed him as the executive vice president. And so we know that that's his title.
Right.
And then reading that in conjunction with the Constitution where they list officers and they do not list the executive vice president, what does it matter that he says he's the second highest person?
Well, because I think you can take him at his word when he says that he
Counsel,
is.
we don't decide cases in this court based simply on what people say. If we did that, this court would shut down, right? We are bound by the documents that control a given transaction or a given relationship. That's how we assess what those relationships are. Your clients are asking us to add to their perhaps ill-constructed constitution that we supplement their failings and add language that doesn't exist to fit the fact pattern here. We never do that. Why should we start here?
Your Honor, if the court, if that is the position of the court, I mean, the Constitution.
It's a question.
The Constitution says what it says. I'm arguing.
Or fails to say something.
Well, agreed, yeah. You know, I'm interpreting it a certain way. I'm asking the court to interpret it a certain way. I'm sensing some.
It's a 32-11 motion, and they've
sensing
given
some
us a
skepticism.
different way to interpret it, which makes a lot of sense based on the Constitution. Maybe ultimately you'll be right. Do you want to talk about the other issue?
I do. First of all, in terms of where he was an employee, the cases cited by plaintiff, in all those cases, that person was hired either to work remotely or hired to work in New Jersey, in fact, but not initially, as here. He, even when working remotely, he went into the office at least 9 times during 2022. Even after he said, I was concerned about retaliation, he does go into the office. And, you know, the New Jersey policy is to protect employers from potential unfairness of having to comply with several different legal regimes merely because they have employees that reside in different states. Now, as was pointed out before, you know, suddenly COVID comes in, there's a lockdown, people have to work remotely, and suddenly ZOA, which used to have only employees in New York, suddenly has employees in New Jersey, suddenly has employees in Connecticut, where people used to commute from. That shouldn't be. The last thing that I hope I have time for is, and if it turns out that he's not an officer, I would respectfully submit that the Second Department got the Ferris case wrong. There should not be a private cause of action under 715-B. The Second Department took the position that, well, because the Attorney General can't do it, someone has to be able to do it. But that's not the analysis. In fact, what this court said in People versus Grasso and what the Court of Appeals said in the Concord case and also in the old Varela case is you've got a comprehensive enforcement mechanism. You've got, I don't have time to count them, 112A, 621D, 715 sub F sub J, 715 sub I, 717 sub B, 718 sub B, 719 sub A, 720 sub B, are all parts of the NPCL that provide for either the Attorney General or a private person or both to bring an action to enforce various provisions of that statute. The fact that 1715 sub B, -B does not, cannot be ascribed to some kind of.
So do you want to continue, or just one moment, do you want to continue and use your 1 minute on rebuttal now and continue your argument?
I just finished this thought, which is that.
Okay.
I mean,
I tried.
Go
ahead.
which is that the lack of that alone, it's not this just that the court is silent, that the legislature was silent on the issue. The legislature was not silent. The legislature enacted multiple provisions of the NPCL that provided for enforcement by either the Attorney General or a private plaintiff or both. The fact that not in this particular section cannot be ascribed to legislative absent-mindedness. It has to be ascribed to a legislative choice.
Thank you.
Thank you.
Mr. Honors, if I may just address the last point made just now in terms of there not having a need for this private cause of action. In fact, the legislative intent, as found by the Ferris case, behind Section 17B is to protect employees who in good faith report any action or suspected action taken by or within the corporation that is illegal. In various provisions of the law, the Attorney General is given the power to enforce those provisions, but not...
I mean, the second department found that they thought that this section created an applied private right of action. So it is implied, but this is how they interpret it. We're not necessarily bound by it, but...
That's right. Well, I think there's also language actually from the findings made in my brief. I will point you to that. There is language made by the legislature that the need to protect whistleblowers in these organizations is paramount. And this is the one provision that doesn't have anything, no language about the AG, the Attorney General, having the power to enforce it. Therefore, this was implied. This private cause of action was in fact implied as consistent with that legislative intent. On the issue of, I'd like to come back, if the court may permit, just to address the choice of law. In the background of all of this is this issue of, well, if New Jersey law does not apply as defendants claim, and if New York law does not apply, as is apparent, I think, from the impact test that I discussed in my papers, then what law applies? Georgia law? Surely cannot be. Pennsylvania law? Surely cannot be.
Why wouldn't New York law apply?
I'm sorry?
Why wouldn't New York law apply?
Because under New York law, under the impact test of New York law, as outlined in Hoffman, as outlined in Wolf v. Imus, as outlined in Packnett v. Moore, the fact that he was working remotely dooms him outside the state. The fact that he was almost exclusively working, 97% of his time was spent in New Jersey in 2.5 years between March 2020.
Except that what he was describing was things that was happening in New York. So I don't understand the analysis that was done to reach that conclusion. And you instead, it seems to me that instead of let's file the complaint in both, whichever one survives. So you make a decision that this one doesn't apply, you go with the New Jersey statute. We say that doesn't apply, and now
respectfully,
now we should do cartwheels to try to make your fact pattern fit?
No, Your Honor. Respectfully, I would disagree with that assertion that it concerns actions taken in New York, because the people who fired him were Klein and Schoen, both of whom worked outside New York.
Things that he complained of happened in New York, right?
No, that has not been the allegation made in the complaint, and that's not clear.
His allegations were that outrageous comments, discriminatory comments, racist comments were made to and about people in New York.
Your Honor, half those...
Counsel, did I read another brief?
Your Honor, if I may point out just something that was...
Can you answer my question?
Yes, Your Honor.
Is that what the brief said?
No, Your Honor.
No?
No, Your Honor. No, Your Honor. And I'll tell you why.
We must have read different
I will tell you
briefs.
why. Because half of those events, with respect, of course, half of those events took place when the entire office was working remotely. He's describing comments that were made from March 2020 through basically 2022. At that
Counsel,
time,
are you
as we saw
saying
in the
that if
record,
we agree with you, we have to toss the case because there's no jurisdiction here? There's no New York nexus?
No, there is a New York nexus. This is a court of general jurisdiction. Supreme Court is a court of general jurisdiction. This is a New York company. He has every right to bring this case in New York and to have New York apply New Jersey law. There's nothing improper about that.
Okay, you're out of time. Thank you.
Thank you.
Oh, you still have a minute. Do you want to exercise that minute? I'm sorry. No?
He doesn't. There was no questions.
I'm sorry, you don't. It was a different case. I've been reading offline all day. Forgive me, guys. I don't have my glasses, so I'm struggling here. All right. Studio 1872 versus Advanced Retail. You see me squinting, right? You didn't notice? Good. All right. Whenever you're ready. Of course.
Good afternoon. My name is Tim Pastor. May it please the court, on behalf of Studio 1872, the appellate and the plaintiff in the underlying action. I listened with interest a moment ago talking about what is in a document and what is not in a document, because that's critically important in this matter. In this matter, we moved at the trial level based on documentary evidence to dismiss the defendant's counterclaims. One was for breach of contract, asserting the very money damages that were released in this document, which is in the record as R37.
I have a copy too, right here.
Have a copy too?
Yes, mine looks just like yours.
That's great. And I encourage you to consult it because it contains an express release of the very claim that the defendant asserted as a counterclaim. And what it does not include is a release from us. Their second counterclaim is essentially seeking breach of covenant and good faith fair dealing on the basis that we sued them for filing a wrongful, fictitious, untimely lien that was filed well after the statute of limitations would permit it to be filed, using a false, fictitious date that contradicts their own public records with the New York Department of Buildings. So when you look at this satisfaction of lien, our obligation to get this satisfaction was to pay the agreed sum, which was $10,000.
And that's something that the parties negotiated, that you were going to pay $10,000. That would
It was, admittedly, it was an agreed sum. But whether it was an agreed sum or the full sum, right, we didn't waive our rights to pursue a remedy for the wrongful lien. Plus, what we learned after we paid that $10,000 was that this construction company, who was our construction company, sought and obtained additional money of ours from our landlord, totally without disclosing it to us. So it turns out we didn't settle for $10,000. We actually paid 28 out of this 37. We're seeking, seems like quite a small bit of money, and we're seeking that $18,000 in our underlying suit, but we're also seeking a remedy for tortious interference and other claims in connection with the wrongful lien, because the lien engendered and created a default under our multi-million-dollar commercial lease. They could have sued for money damages and we would have no remedy, but they filed a lien, and they filed it well beyond the statute of limitations. Understand, our store was closed due to COVID. At the time, they said they were providing labor and materials to our store. We had been closed for 8 months, and they had already certified to the New York City Department of Buildings on December 6, 2019, that their job was completed. And yet on their lien, they put November 20th, 2020. Okay, that's a big difference. And here, the counterclaims are for things that were expressly released in the first case of the counterclaim, and the second counterclaim is seeking relief that is not released. We reserved all rights. We never waived our rights. We're entitled to satisfy a lien and deal with it later. And if that's not the law, then anyone that's trying to get a mortgage, trying to get a refinancing, or dealing with like we were, a default under a commercial lease, they'd be hamstrung. You can take care of that lien and then address it later if you want to pursue a remedy. That's what we did. They have no basis for their second counterclaim seeking relief because they got sued for their wrongful acts.
Thank you.
Good afternoon, Your Honors. I apologize that this case is less exciting than the previous two, I heard.
Oh, no, it's exciting because when I read the record, I was wondering if there was a scam being perpetrated.
By our client?
Oh, yes.
Oh, no. I would say quite the opposite. It's very fascinating the way that the defendant, I know we're here in the counterclaim, but I want to give a little context if possible.
Well, the context is a release that says they will never file a mechanics lien and release forever, right? A Studio 1872. And then the other context, that's one. Then the other one is the letter of completion, which says to DOB, the Department of Buildings, that the work has been completed due to a sign-off on December 6, 2019. It's followed by a notice of mechanics lien, a mechanics lien that says that the work was finished in 2020.
Your Honor, I appreciate that. While that's not directly related to the counterclaim, I'd like to answer that. The lien law is somewhat broad about whether it's delivering materials or labor to the lot. And in this case, they paid that lien. They didn't move to discharge it immediately. Their whole argument is that how dare we make them default on the lease they were in default under. They weren't paying rent. Their argument is that how dare we, they didn't pay us and they don't pay their landlord, how dare we prevent them from not paying everyone who they owe money to by filing a lien which gave them a non-economic default. The reason that they blame us for the default is because of COVID. 3 years earlier, they'd already be in default because they weren't paying rent. But because there's...
Let's just focus
But that's
on
not the issue.
No,
So why don't we focus?
I was going to say.
And let's talk about the release.
Yes.
Right? Because the release that was your release for them. Like, you released them. It didn't go in the reverse.
Oh, that was not...
You got really excited. Did it go in the reverse?
I just wasn't aware this thing wasn't attached.
Okay.
So I put my pressure on, my weight on it, my considerable weight on it. So here's the thing about that release. It was signed by Mr. Pastor, who's a good person and a great lawyer, a lawyer on one end, and Mr. Malley, the contractor, on the other, who is, to put politely, not a Rhodes Scholar. This is now an article, a CPLR 3211A5, so it's a release. It's not that clear. It was written pretty unilaterally, written by a lawyer on one end and very much a layperson on the other. So already you're looking at a 3211A5 motion, which is strict, and then you add the fact that, well, does it actually say, yes, setting aside the fact that it's quite unfair that it's unilateral, what does it say? I'll read the preamble that by the way, Mr. Pastor made my client add.
We read it. We are clear about it.
We have it.
So explain to us how you are able to file a suit after having signed that.
They released Forever Studio Inc. and respected from any claim for money damages for full amount of the mechanics lien. It doesn't say for the contract. I agree.
But what would the contract be for, though?
The original underlying contract, because there was obviously an original underlying contract that they breached. Obviously, when you have a lien, you can both sue for foreclosure of the lien because of the amount and just for the contract in general.
But the contract would be for the money that would be owed, right?
Usually, generally speaking, you're filing a lien for whatever remains on the contract. I've seen it where it's like weird, where it's like filed for different amounts. But by and large, sure, this is a 3211 motion. It has to be very strict. It's not that, it doesn't say for the full contract. Do I think it's great that would I rather there be no release at all? Of course.
So they owed more than the $37,000 that the lien is referring to?
I don't want to speak out of turn. I don't particularly...
Because if they owed what the lien says, and then you settle the lien, you satisfy the lien for $10,000, and the lien contains a release saying this is it, then where do you get the other 18?
Because a lien, Your Honor, is nothing more than an encumbrance. It's not the underlying claim. It's the same way there's a mortgage and a note.
I guess we're talking in circles, because I just asked you if they owed more than the $37,000.
No, they don't. So they've released the lien. The question is, they released the claim as well. Because the contract claim technically is independent of the lien. I have a case now where we knocked out the lien because it was filed.
But you released it, like, because you could bring no claim for money damages pertaining to this matter. Like, I don't understand. What else are you asking for?
The whole reason we brought this, or my predecessor brought this counterclaim, is because the claim is, if you're going to, after this release and after we settle this thing, if you're going to now sue us claiming we interfered when we didn't, and we didn't, it's made it very clear, by the way, that we don't have to not get money from the landlord. That's a concocted claim. But if you're going to sue us, the theory was, you're not respecting the release, you're not respecting the spirit of the release, that's why we're going to sue you. One claim is for contract, and the other is for good faith and fair dealing.
But inside the release, did it say that they could never bring an action against you?
It doesn't, and perhaps if my client had an attorney and I didn't see any emails. I don't want to cast aspersions. I don't think I saw anything in the record saying where he said to my opponent, my client, you really should have an attorney for this. So if I had drafted this, that would be a very fair criticism. But given that it's strict interpretation plus an unrepresented individual and a release that doesn't say the contract is gone, I think I'm not saying we're going to win or even survive summary judgment, but this is a motion to dismiss. It's a pretty strict standard against him.
Thank you.
Thank you, Your Honors. Hopefully I wasn't boring.
I'll be very brief. First of all, it's not on the record, but I did, as I routinely do with unrepresented parties, indicate that if he would like to refer me to his counsel, I'd be happy to speak to his counsel. So I just want to clarify that. Also, counsel seems to be conflating that there's a lien and an underlying claim for money damages. Well, the release contemplates both of them. And in the record, at pages 126 and 127, there's correspondence where I indicate to the adversary, to the opposing party, hey, you only addressed the release, the satisfaction of the lien. You didn't also address the money damage claim. I could pay you for a satisfaction and you could sue me for money damages tomorrow. I need both. And what they have done is conflated. These are two separate obligations. Both of them were released by the express language here. They cannot assert a claim for money damage. And to the extent he's talking about the contract still being in place, what would be an outgrowth of a breach of contract? Money damages. And that's what we got released. So if he thinks that there's some other basis to concoct some other claim under his contract, I suppose he could try. But here, they asserted the claim that was precisely and expressly released.
Thank you.
Thank you.
People versus Eugene Miller. You may proceed.
Thank you. Good afternoon, Your Honors. I'm Benjamin Weiner on behalf of the appellant Eugene Miller. The court below summarily denied Mr. Miller's request for new counsel without asking a single question. This was not the minimal inquiry that's...
Is that the standard though, or is it that the person has an opportunity to voice what their issue is? Because I know that in your brief you relied on certain cases where in those particular instances, I can agree, because in one instance, the court didn't even ask, wasn't even talking to the defendant, was talking to counsel, and in the other case, there was no inquiry. But in this particular case, there was a colloquy, well, what's wrong? I haven't seen my client, I'm seeing my attorney, well, he's busy, he's a good lawyer. I mean, there was a whole exchange. Why isn't that enough?
Well, there's nothing that can be characterized as an inquiry here, and I direct Your Honors to pages 2 to 3 of the hearing transcript where this occurs. The court comes on the record. Nobody has had an opportunity to speak. The lawyers have given their appearances, and immediately the first words out of the court's mouth are, I understand you want an attorney, and I'm denying that request. What the court says is, I can't get you a better attorney. The court doesn't conduct an inquiry. It doesn't ask Mr. Miller to explain the basis of his claim. It doesn't ask counsel any questions. It doesn't invite any further discussion. Mr. Miller manages to get a word in edgewise and say, my lawyer isn't visiting me. That comment itself should have it did spark a duty on the part of the court.
Was the timing of the defendants seeking new counsel a problem? I mean, it was a problem, if you could address that, because he'd been in the case for a long time, and it was very close to either the hearing right before the trial. So what about that?
That's right, Your Honor, in
judge
terms
is
of
entitled to
the timing, and that is a consideration that could have come into play had a minimal inquiry been done. Once the court was making a discretionary determination following a minimal inquiry, it could have considered the timing of the request in assessing whether this was a dilatory tactic. But this court has been very clear that even when a request is made before a suppression hearing, as it was in this case, or on the eve of trial, the court must conduct at least a minimal inquiry, sufficient that it can carefully evaluate the request. That's what side says. And that just wasn't done here.
But so basically, if I understand your argument, is that the court didn't ask a question.
That's right.
Is that the argument?
That's right.
But he was allowed to tell the court why he needed an attorney.
Well, again, he's not allowed to say anything at all. They come on the record.
He's never shut down, though. I mean, I understand what you're saying, and I get it. I understand the interplay between judge and a defendant, right? But so he starts. It's clear from what the court says at the first instance that he's been apprised that the defendant has an issue with his lawyer, right? So he brings it up and he says, I understand you're dissatisfied. So he's letting the defendant know, I know you have an issue. And to me, that opens the door for the defendant to say what he wants once the judge shuts his mouth, right? And he says, he needs to come see me. I don't see him like that. And then the judge says, they're very busy. He responds, I need a new lawyer, Judge Carroll. And then the judge responds, I can't give you a new lawyer. But there's back and forth. And there is, at no point does Judge Carroll say, I've heard enough, be quiet, we're going forward.
What the court says before Mr. Miller has any opportunity to speak is, I can't get you a better attorney.
A better attorney is not, I cannot get you another attorney.
I think it's very clear from this colloquy that the court is denying the request before Mr. Miller speaks, and in any event...
Well, but then it continues, right? The Mr. Miller gets an opportunity to say that he needs to come see me. I don't see him like that. And then they go on. There's an exchange. And you know, I looked at the other cases that you rely on. I went back and I looked at the transcripts in those cases to see if there were any similarities, and it's starkly different. In those other cases, there was no opportunity at all to say anything. And in one point, it was an exchange between the lawyer and the court. The defendant said nothing. That's not what we have here. And in the other case, there was no, there was an exchange, but it was more of the court not listening. And that's not what happened here. This person got the opportunity to say what they wanted to say. My lawyer is busy. He needs to come see me. And the court engaged him. That there was a minimal inquiry. I understand that you're saying there wasn't a formal question, but he understood his concern.
There is nothing that can be described as an inquiry.
Do you want to hit another issue? Because you have 1 minute left.
I want to stick with this issue,
Okay.
Your Honor, because even if you ignore that first part of the colloquy, if you start with Mr. Miller saying he needs to come see me, I don't see him like that, that's the kind of comment that under sides requires a minimal inquiry. There is no inquiry done after Mr. Miller makes that comment. Instead,
Counsel, I'm sorry, but this is not a atypical complaint of defendants. And properly so. If I were in jail, I would want my lawyer to come see me every week. So I get it from their perspective. But this is not a unique statement to a judge. We hear this all the time. As defense attorneys, you hear that all the time. Man, you don't come see me enough. You haven't sent me my papers. There's a whole slew of typical complaints, and some of them may be absolutely justified, but they're not earth-shattering in the continuum of the things we hear in this business, right? I know you have a whole lot more to say on this, and you'll get a chance on rebuttal, okay?
Thank you, Your Honor.
All right.
Good afternoon, Your Honors. I'm sorry, Jared Walkowitz for the people, may it please the court. I want to focus in on what you, Justice Manzanet-Daniels, and Justice Mendez were talking about, because I do think both of them together really fit it. As you were pointing out, Justice Manzanet-Daniels, what happened was when the court was obviously clued in to the fact that the defendant was dissatisfied. So when he got up there, he says, I understand you're dissatisfied with your attorney. And when you clued in on that, Justice Mendez, about the better attorney, he was basically saying what he had heard off the record. But as you were all discussing, he was allowed 4 pages to speak with the defendant about this, and the context shows that the defendant was allowed to explain why he wanted a new attorney, which was that he didn't see him enough, and the court explained to him that that was not a valid basis. He's busy, and as Justice Manzanet-Daniels was saying before, that while we want, like everybody would want their attorneys to see him every day or every week, it's just not possible. So, Your Honor, everything here is in context. And secondly, I do want to point out that this was, as Justice Kapnick was pointing out, an eve of trial request. So you have to not only, in that circumstance, give a reason, it has to be a compelling reason and an exigent one at that late stage, especially since they had never before once brought up counsel as an issue.
How long had the case pended prior to the date that he made this request?
About 1.5 years.
And how many appearances had he made in that 1.5 years?
I can't give you a number, Your Honor. I'm sorry about that. I don't know the number of that offhand. I know Your Honors had asked him about anything else. If there's any other...
Well, the other issue that was briefed was the issue of the admission of various out-of-court statements and whether they fell under a rubric of any exception to the hearsay rule, and if not, were they of such a nature to constitute reversible error?
Your Honor, with regard to the statements, many of the statements were perfect. They treat all the statements as inadmissible hearsay, and that's not true. Many of the statements were admissible for many reasons. First, they were defendants' admissions. Second, people had seen the events. Third, they went to the victim's state of mind as related to the defendant's state of mind.
How about statements made by people who say they overheard the defendant say something? That's an out of court statement being offered for the truth of the matter asserted, not just the fact that it was said.
Well, I would disagree with that, Your Honor, if we're talking about the same thing. If a witness overheard the defendant say it, that's an admission by the defendant, and that's permissible. That's black letter law. If the question is, and we've conceded this.
Depends on what was said.
Well, no. I mean, if the defendant.
No, if the statement is, I'm going to kill you, yes, that's an admission. If the statement says, if the statement was, she's a terrible mother, that's an out-of-court statement that would not be admissible, right?
Well, the statements were, I'm going to kill you. Both of those statements.
But not all the statements were that.
Well, in this particular case, they were, or in context of, they were relevant towards this particular.
And also, weren't there also statements that were talking about what was going on in the context of their relationship?
That's what we get to.
Yes.
I was going to say that there were a few statements, by several witnesses, by I think 5 or 6 witnesses, and we pointed this out in this brief, where the victim was recorded saying something by a witness who testified, but it was outside the presence of the defendant. That, after Brooks, would not be admissible.
Right. So that was the problem, that the Brooks case came
In
after
between.
the trial.
Exactly. But we have argued they're harmless because most of those statements largely
Were in admissible form.
are covered by admissible evidence. Plus, even if you were to extract every single piece of out-of-court statement from this case, the evidence through the video statements, through the phone records, through the defendant's lies to the police, more than satisfied proof beyond a reasonable doubt and overwhelming evidence so that it would be harmless. And it's especially harmless, as I said before, because every time you start adding a statement in that they're claiming is out, like a defendant omission or something where the defendant did hear it, that makes it less and less harmful. So because of the proof beyond a reasonable doubt, because of the overwhelming evidence in this outside of the statements, any statement that we have conceded that was admitted and those were outside of the defendant's presence, that would be harmless, and we would ask that the court.
And the defendant's statements acknowledges that he is the person in the video.
Yes. At least to the extent that he admits running out of the building.
Right. Thank you.
So as to the timing issue, I want to refer your honors to People versus Rodriguez, which we cited in our brief. This is what the court said. The timing of defendant's request and his history of changing attorneys were important considerations. Nevertheless, the court had no basis to completely cut off discussion without hearing any explanation. In other words, a sides inquiry must be conducted no matter when.
But see, even with that case that you're talking about right there, the judge didn't cut him off without any explanation or any inquiry. He found out what the issue was and he addressed it.
Well, again, and I think this returns to your honor's very good question about the nature of Mr. Miller's complaint about counsel. Saying your lawyer isn't visiting you, not enough on its face to get a new lawyer, but that's what we have the sides inquiry for. The court should have asked.
Yes, but this is but look, I've written on this issue. I'm sure you read my decision in preparing for this case on this issue. So if I have a defendant who's saying, but judge, blah, 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 and the judge responds and he responds again, but judge, the defendant is providing the additional basis for further inquiry. But if I make statements and your response is, but he doesn't come see me, and the judge says something and the next response is not, but this, and that, he gives him nothing.
Well, what he says is, he doesn't come see me. The court says they're very busy. He says, I need a new lawyer, and the court says, I can't give you that lawyer. The court needed to
But
ask
again,
some
I need a new
questions.
lawyer. He doesn't say he's given me none of my paperwork. I've seen none of my motions. I've asked him for all of the evidence in this case, and he hasn't given me a copy of any. He says nothing.
But those are the questions that the court should have been asking. They should have been asking Mr.
What
Miller
case
those.
says that a judge has to ask a defendant when they say, they didn't come see me? Has your lawyer given you all of the paperwork? Has he given you copies of them? There is no case that says that.
Side says that the court has to conduct a sufficient inquiry that they can carefully evaluate the request. And we cited cases in our brief where statements that a lawyer is not coming to visit a client should prompt a further inquiry by the court, and that didn't occur here.
Do you want an additional 45 seconds to address any of the other issues in your case?
Sure.
You hung your entire hat on this issue.
Sure. So as to the hearsay, the statements about Mr. Miller's conduct that occurred, that aren't directly observed, those are definitely hearsay, and it's not harmless because this is an incredibly important part of the prosecution's case. The motive is critical to the prosecution's case.
They had plenty of admissible evidence to demonstrate the motive here, the underlying breakup of the relationship, his constantly threatening to kill her. If I can't have you, nobody's gonna have you.
I mean, even was it on surveillance tape or someone saw him or both? Wasn't he there the day before?
He was, Your Honor. But again, the prosecution's whole theory of this case is that this is escalating threats and violence. And many of the prior threats and prior allegations of violence come in through hearsay testimony. And that is
But there's
why
still a
it's not
significant portion that doesn't come in through, that does come through admissible testimony, the party admissions, where other people had heard him say, I'm gonna kill her.
But we don't have to establish that but for the admission of this evidence, Mr. Miller would have been acquitted. We just have to show a
But the
reasonable...
point is that there was overwhelming evidence. Even if these things happened, it was not harmful, it was harmless.
But even if there's overwhelming evidence, all we have to show is that there's a reasonable probability that this impacted the jury's verdict. And this was important evidence in the prosecution.
And on what basis would that argument be made? This man shot her in the head 3 times.
Which, again, nobody observed him doing that. And that's why this evidence was so critical in this case, was because the prosecution was able to say this was the culmination of behavior that Mr. Miller had engaged in the past. And that's what the hearsay evidence let them establish. Thank you, Your Honors.
Thank you. All right. RREF 3 Storage versus Paul. You may proceed.
Thank you. Good afternoon, Your Honor. Aaron Lockheimer, Morrison Cohen, on behalf of the appellants. Back to commercial cases away from murder. Your Honor noted earlier that this court follows what contracts say and does not interpret clauses in ways that are inconsistent with their terms. And Your Honor, I think that nails this case, at least on this appeal. This appeal, Your Honor, concerns whether or not the lender, the respondent, is entitled to a yield maintenance default premium under the loan agreement. Your Honor, before we get there, the answer to that question under the loan agreement is no, because the loan agreement states that they're only entitled to a prepayment penalty if there's a prepayment.
Right.
And Your Honor, the lender in this case chose to accelerate the loan on
And once they accelerate the loan, then you had no option to prepay, did you?
That is
your
correct.
point, right? Isn't that your point?
That is exactly right, Your Honor. That's exactly what the court said in AMR, that upon acceleration, a payment is a repayment of the loan, not a prepayment of the loan.
And it seems to me to hold otherwise would provide an incentive for the accelerating of payments of loans in order to collect prepayment penalties.
Correct, and Your Honor, if the lender wanted that provision in the loan agreement, which the cases that they rely on all contain, they could have negotiated for the right for a prepayment penalty if they regardless, if they chose to accelerate. They didn't do that. That's not what the loan agreement says. And so, Your Honor, as I noted, the AMR case, I think, states very clearly, which is a Second Circuit case applying New York law, that A prepayment can only occur prior to the maturity date. The lender chose to advance the maturity date as defined in the loan agreement when they chose to accelerate on December 6, 2019. The exceptions that they rely on, that the agreement provides for a prepayment after acceleration, or if the agreement provides for a prepayment premium in connection with any payment, simply doesn't apply here. It's not what Section 2.4.3 of the loan agreement says.
Wasn't Judge Maisley concerned to some extent in reading her transcript that she couldn't really find any good New York State cases that sort of supported this position? As you've indicated and as we were looking at, you've put in your briefs, a lot of them are federal cases.
That is true, Your Honor. However, I would note in the AMR case, which is the Second Circuit case, it does cite to New York law in spades. It cites to the Capital Ventures versus Republic of Argentina case, which states under the New York law that a specific provision governs the circumstance to which it is directed, even in the face of a more general provision. Right here, it's very specific. 2.4.3 is crystal clear. It's very specific as to when a prepayment penalty applies, and it doesn't in this case. And if Your Honors take a look at AMR, it cites to other New York cases as well, because the indenture in that case was in fact governed by New York law. I'll just move on very quickly, Your Honor. Recognizing that 2.4.3 doesn't really solve their problem, they cite to other arguments relying on other provisions of the loan agreement, none of which support their position. They cite to the definition of a yield maintenance default premium to try to create the existence of one. That is just a definition. It doesn't say it doesn't trigger a payment. It states
Didn't they also respond to a couple sections of Section 10, the default article in the contract, 10.1 and 10.1A and 10.1B?
Correct, Your Honor. And in those provisions, they cite to those provisions the proposition that they had to accelerate in order to foreclose. In fact, Section 10.2 says the exact opposite, because if Your Honors look at 10.2, what it says is there's two provisions. One says you can foreclose on any missed payment whenever you want. The second clause says you can elect to accelerate. That's the language in the loan agreement. If the fact that it says in one place that they could choose to elect, and it doesn't say that in the other, which is what we're dealing with here, they chose to foreclosing and seeking to collect on the missed payment, that was their choice. They didn't have to, there's no automatic acceleration upon foreclosure. It's not what 10.2 says. It says the exact opposite, as Your Honor would note. The last provision that they cite to, so I mentioned the definition, that doesn't change when a prepayment is due. It simply provides a formula for this computation. They also cite to Section 2.4.1 for voluntary prepayments. Again, that section does not apply. That deals with when payments are due on a voluntary basis before acceleration. Once the loan is accelerated, it's not voluntary anymore. Payment is due immediately. Yeah. The last section they cite to is 2.4.2a, liquidation events, to try to argue that there was a foreclosure of the property, a sale of it, and that ultimately triggers a prepayment premium due. Your Honor, they have some kind of negative implication argument that because it doesn't say that a prepayment is due under two limited circumstances not applicable here, and all the other circumstances, therefore, a prepayment premium is due. That's the exact opposite of the state proposition they rely on. You can't cite to the absence of a provision to state that, therefore, in every other circumstance, you get some kind of relief. That's just not the law. Thank you, Your Honors.
Thank you.
Thank you, Your Honor. Joseph Palmore for respondent lenders. I would like to go right.
Counsel, I have an easy question for you.
Okay.
So, to the extent that the lender has accelerated the loan, why should there be a prepayment penalty?
Well, Your Honor, New York law is clear, and this is the NML Capital case that we cite in our papers. This is from the Court of Appeals. This is the only binding precedent that either party has cited in this case, that parties to a loan are free to specify in the loan the consequences of acceleration.
But where does it say that acceleration of the loan by the lender will result in a penalty?
Your Honor, there's no such clear statement rule. In fact, NML Capital rejects
No, I'm talking
Capital
about
Ventures
here,
case.
I'm talking about the underlying agreements.
Sure.
Where does it say in the record that acceleration of the loan by the lender would result in a penalty?
So it says that because of the foreclosure provision in 2.4.3. If you just give me a minute, I'll explain what I mean. Foreclosure only happens when there is a payment due and owing.
So we know that.
There's no such thing as a voluntary foreclosure, right? So even the two provisions that my friend on the other side referred to, either there's a partial or complete acceleration, or the borrower missed a payment and it's due and owing.
Are you conflating foreclosure with acceleration?
No, Your Honor. What I'm saying is the argument on the
You
other
seem to
side.
be saying that they equal the same thing, and they don't necessarily.
What I'm saying is that under this contract, there can be a prepayment even with a payment that is due and owing. Either there's been an acceleration or there's been a missed payment.
Counsel, you're asking us to ignore the plain language of this provision.
No, Your Honor. I'm
Yes, you are. It is real, crystal clear in this language. And as your adversary stated, the party that you represent could have very easily included language in this contract that said there's prepayment interest, whether we foreclose, whether you do it voluntarily, it doesn't matter. We get our interest no matter what. That's not what this says.
And that's not what the New York Court of Appeals requires in NML Capital. There's no magic words test. There's no clear statement rule. To the extent Your Honor is
Counsel,
suggesting that
these are the words that were quoted by the parties in question. So when we look at 2.4.3 of the junior mezzanine loan agreement, it only says prepayment. Why should
Exactly,
we
Your Honor.
read or acceleration of the loan into this language?
because the question is, well, what does prepayment mean, right?
Well,
And there's
but is there a definition that says prepayment also means acceleration?
no, Your Honor.
Therefore, aren't we bound by that?
No, because New York law does not provide a uniform definition of prepayment. This is not a
So
term
you're
of
saying
art.
that in a provision like this that does not state specifically, we get prepayment interest regardless, where there's no provision that says that you could have added but didn't, that the court should then look to other provisions throughout the entire contract and see if there's any other way that we can get you your prepayment interest.
No, Your Honor. So the word prepayment where I was going is, look, this is a prepayment. It was made before the
Because
stated
it was
maturity date,
accelerated.
but it was made before.
Because it was accelerated, not voluntarily.
It was due and owing, and this-
Because it was accelerated.
Yes, Your
We're not
Honor.
going to ignore that, counsel.
It was accelerated, it was due and owing, just as in a foreclosure situation, it is due and owing.
Could you have declared the borrower to be in default and not have accelerated the debt?
Yes, Your Honor.
And did you do that?
No, the debt was accelerated.
So then, had you done that, declare them in default and not accelerated the debt, and had they then paid you the debt, then they would have been responsible for a prepayment penalty in that case.
And I think
Unquestionably,
that
Your Honor.
that's what 2.4.3 contemplates.
I disagree, Your Honor, of course. So if you look at 2.4.1 talks about voluntary prepayments. 2.4.2 talks about mandatory prepayments. 2.4.3 talks about payments after default.
Right.
Regardless of voluntary, involuntary, if there's a payment, a prepayment after default, and this is
It says during the continuation of the events of default, which kind of goes with what my colleagues were saying, that they've been declared in default, but you haven't accelerated the loan, right? Because the events of default can continue, and you're going to get your prepayment.
right, but it's continuing or after, right? So there was an event of default here. The payment was tendered. It was prepaid because it was paid early. There's a stated maturity date in the contract, right?
But once you accelerate the debt, basically you've accelerated the maturity date of the.
Right.
Right.
I mean, the stated maturity date stays the same. You stated a maturity date, and that was the stated maturity date. But then, if you accelerate the rate, accelerate the amount due, then you've created a new maturity.
Right, it's due and owing at that point, just like in a foreclosure situation, it's due and owing because the payment was missed, that's due and owing, or a partial acceleration or a complete acceleration, it's due and owing. And 2.4.3 calls that payment a prepayment.
All right, thank you.
Thank you, Your Honor.
I'll be very brief, Your Honors, unless you have any questions. Counsel pointed to the NML case as the New York state law cases that applies here. I just think there's two very relevant quotes that I'll read for Your Honors that I think address exactly what we're dealing with here. The court in that case stated, the parties to a loan agreement are free to include provisions directing what will happen in the event of default or acceleration of the debt, supplying specific terms that supersede other provisions in the contract if these events occur. They could have included a provision that says we get a prepayment penalty even if we accelerate, and they didn't. The other quote, Your Honor, is the Court of Appeal stated, as we have indicated in New York, the consequences of acceleration of the debt depend on the language chosen by the parties in the pertinent loan agreement. Again, Your Honors, that's the language they chose. It's the language they have to live by. Unless Your Honors have any other further questions, I have nothing to add.
Thank you so much.
Thank you, Your Honors.
Sanarcine versus 84 Lumbar Company. Justice Mendez is recused on this case. Should there be a tie, another judge will be vouched in accordance with the Appellate Division First Department rules.
May it please the court. Just one explanatory note. I will refer to this court's decision in the Nemeth case as Nemeth 1,
Okay.
and the Court of Appeals' subsequent decision as Nemeth 2. This case presents a question which is governed by the Court of Appeals' 2022 decision in Nemeth 2. Specifically, that question is where Dr. Jacqueline Moline offers substantively the same expert opinions as were offered in the Nemeth case in support of an asbestos contamination theory. Is that, without more, legally sufficient to establish specific
But
causation?
go ahead. Well, I was just going to say, I was on Nemeth 1, couldn't be on Nemeth 2 because I don't sit in that court. But in any event, so I'm pretty familiar with Nemeth, and I'm aware from the number of asbestos cases that come up here that Dr. Moline testifies very frequently in these cases, and I guess there's a group of experts that come to, create an expertise. But I think, and how can you disagree, that Nemeth is really very different. Because the situation in Nemeth was someone at home using talc. They weren't exactly sure how much. She did a test, what was it called, a dust box test or something. She shook it up. She tried to figure it out. I mean, that was a very different situation. Here, for years and years, there have been cases involving asbestos with drywall, with workers, where they have lots of scientific evidence. I know it was the same expert, but her information, her testimony was very different. I do not think that this case can rise or fall on what was decided by the Court of Appeals in Nemeth. I mean, how, you don't see a distinction here?
I don't, Your Honor. And I think it's significant here. It depends upon the theory of the case that the plaintiff presented. And that theory was an asbestos contamination theory. Mm-hmm. And I do not make the contention that the opinions of Dr. Moline were substantively the same lightly. And what I think is illustrative is to look at Nemeth 1 in terms of how it describes Dr. Moline's testimony and compare it with the record in this case. First, we'll start with the glove box, which was the method used in Nemeth 1.
I don't see that the two are comparable at all. A woman sprinkling powder at home is not the same as a worker standing inside a building with a bunch of people sandblasting drywall. It's not the same. And for you to pretend that it is just kind of loses me immediately.
And I guess the question that really needs to be asked when we're talking about specific causation, as it was detailed in Nemeth 2, we just need to find out in this particular case, was there a specific comparison sufficient to show how plaintiff's exposure related to other subjects? And we have that here because, as my colleague indicated, this particular line of transmission of asbestos that results in mesothelioma. Right, thank you. There's a litany, a whole history, studies, comparisons. Workers have been studied for years. It's very different from that one glove box test.
Well, Your Honor, I'd submit that the generally accepted science indicates that a much higher exposure is required to cause the plaintiff's injury. And here, it's important, I think, to look at the opinion in the trial record itself, because irrespective of the general differences between the plaintiffs, the trial record indicates that the same theory was employed that was employed in Nemeth 1, and it's largely a question of timing, because this case was prepared in 2020. It was put on hold due to the COVID-19 pandemic. So during that period of time, Nemeth 1 was the law of the land. But if you look at the theories presented in Nemeth 1, that brief or low-level exposure to asbestos-contaminated talcum powder causes all forms of mesothelioma. Dr. Moline testified to that in this trial at page 732 of the record.
But there was more to back it up. Nemeth 1, I mean, you keep referring to that, but we have Nemeth 2 really for the guidance of what we need to be looking at. And her testimony, I mean, what she said in this particular case is much more detailed, right? We have to look at the historical data and the science that she backed it up with. That's where the difference comes in.
So, Your Honor, I would refer to this court's case in this court's decision in the Dyer case. And what this court said post Nemeth 2 and Dyer is that even where some reliable methods are used, for example, here, arguably, the methods to measure the joint compound, if there is too great an analytical gap, then that is still legally insufficient. And here it is. I would refer to pages 746 to 777 of the record, which is the causation hypotheticals that were posed to Dr. Moline. And here is all she says about a level of asbestos exposure, that they were, quote, elevated, that they were, quote, regular, and that they were based on a question about the plaintiff working with visible dust. That's it. So whatever evidence they put on about the level of exposure from some other
There was a lot more evidence than that,
They never
Counsel.
connected.
I mean, I'm sitting here listening to you, and I'm like, are we talking about the same case?
Well, the other issue, Your Honors, is...
She referenced the 1970s Mount Sinai study. She went on to talk about the authors of that study. She talked about how he was his exposure was between 5.3 fibers, and she went on to elaborate how many breaths per second and the massive exposure. I mean, you're talking about pages like 754. I mean, there was like 10,000 more pages in that record.
True, and a key part of their case that is not divisible from any other part of it is that the asbestos in the joint compound and the talc in the joint compound was contaminated with amphibole asbestos. That was their theory of the case. That was a similar, almost substantively the same.
And you want to compare the drywall, sandblasting and drywalling and sanding down drywall with asbestos compound. You want to compare that to the sprinkling of powder after a shower. That on its face is ridiculous.
Okay, Your Honor.
It's ridiculous and is contrary to human experience.
Well, Your Honor, if I may, the other problem, aside from the contamination that was never quantified, no one ever said how much of a contaminant was in either the talc or the asbestos. There were 4 types of joint compound sold during the relevant period, and only one of them had talc, and so that's legally insufficient under the Healy case. And finally, the plaintiff's video deposition testimony was inadmissible hearsay.
Why? Oh, go ahead, go there. We want you to go there. Go ahead. Tell me why.
Because Kaiser did not have notice of the deposition.
Well, obviously, because they weren't in the case yet, right?
Correct.
So that makes sense. But given that they did have an opportunity, the judge did a very good job of explaining this, and based upon the CPLR section, I know what it says, but saying that as soon as they got into the case, you were allowed an opportunity to depose the plaintiff. You could have, had you wanted to, also done a videotape deposition, but you chose not to for whatever reason, and you were able to ask.
Because the man was on the brink of death and probably looked like he was on the brink of death. So your strategic choice, a wise one, I'm sure, to not videotape him, doesn't now equal that you have been prejudiced by the admission of the videotape that was done before you were in the case.
Well, first, if I may, CPLR 3117A3 doesn't contain a no prejudice requirement, but we were absolutely prejudiced by
Why?
the lack of notice that the plaintiff would.
Why were you prejudiced? I mean, I'm trying to understand. I know it doesn't say prejudice in there, but how were you prejudiced when, once you were brought in, you had an opportunity to also depose the client? And look, I have these cases all the time. Defendants always get added on. And we don't say, okay, come ask every question that every other defendant. We said, you ask the questions relevant to your client, whatever. You weren't stopped from asking those questions. You could have asked whatever questions you want. We have a transcript.
Well, Kaiser cannot ask questions about subject matter it doesn't have notice of. And it was never given. What makes this case unusual?
Counsel,
what did you
truly, counsel, you're not making sense. The questions that were asked of the decedent were questions pertaining to his immigration status in large part, right? That was a choice. You could call it a tactical choice, but it sounds more like a strategic choice to deliberately not ask a whole lot of questions so that this argument could later be made. There was no limit on what could be asked at deposition. The choice was in your hands.
And
Why
to
are you
perhaps taint him in front of the jury because he's not an American-born person?
Your Honor, those questions weren't posed by Kaiser's counsel. And the other point I'll make is, again, we had no notice that the plaintiff was going to pursue a claim against Kaiser. They waited until after the plaintiff passed to make a claim against Kaiser.
But you were in the case and you were there for indemnification and contribution. Those were the claims that you were brought in on, and that also involves all the other cases. I mean, indemnification, contribution for damages. What else are you indemnifying? And
Which had to do with your product, so you know exactly why you were there. But you'll have time on rebuttal.
Thank you, Your Honor.
Good afternoon. May it please the court. Jim Kramer from Simmons Hanley Conroy on behalf of plaintiff respondent. Justice Kapnick, as you indicated, you are very familiar with Nemeth 1, as am I, for better or for worse, because I tried that case, and I'm intimately familiar with the facts there. And
sure, you know it much better than me.
Well, what I do know is this, and I agree wholeheartedly with Justice Adams when she said in her decision below that there are vast differences between the evidence presented in that case and the evidence presented here, much of which has already been vocalized by Your Honors. To be specific for the record, here we had Dr. Moline testifying regarding scientific expression. And what I mean by that is she relied specifically, as Your Honor pointed out, on the 1975 Roll, Langer, Selikov drywall sanding publications from the 1970s. Not only that, she had the benefit of the evidence, and again, there's a whole record of evidence here beyond that which was quoted by my colleague today, demonstrating that an industrial hygienist came in. She relied on his report, talking about the numbers historically from real-world simulations of this very type of work, demonstrating that the levels that would increase risk were orders of magnitude below what my client experienced during his career sanding, using a pole sander, hand sander, sweeping this very type of product. Now, much was said about the theories of the case being somewhat similar, and to be quite frank, that's not a matter of record.
You got mesothelioma from a long exposure to talc and asbestos. I mean, obviously that's the theory, but I don't.
That's a common theory, but
Yeah,
there's a key distinction here in the various types of products. So in Nemeth, obviously that was a cosmetic talc case where asbestos was not an intended ingredient. However, it was a constituent, being an accessory mineral. Here, there is no dispute, and the jury got to hear all this, that the product at issue contained by design 10% chrysotile asbestos. And that was, as we brought out during our hypotheticals of Dr. Moline, what she based her causation opinion on. And when she gave the basis for that opinion, she resorted back to Mr. Pascal's report, his testimony in the case, the testimony of my client, the testimony of the literature, and other such materials which constitute the scientific expression, which was enunciated by the Court of Appeals in Parker and merely reiterated by that same court in Nemeth. And this court need look no further than its own decision in McWilliams, which I believe was only issued 2 weeks ago, dealing with these very same issues of what it means to prove specific causation. In that case, as here, An industrial hygienist gave testimony. An epidemiologist quoted the very medical literature relied on by Dr. Moline here, demonstrating at levels as low as 0.15 per cc, you're going to see increased risks of the very disease that my client got. So there is without question, and I think this court has already decided via McWilliams, via another case called Sasson, that the scientific expression has been met. The jury considered it. Justice Adams, of course, reiterated it in her decision. Touching very briefly on the hearsay notice issue under 3117, I think your honors have made clear where you're leaning there. I will say that under the terms of that, the CPLR, as well as the case law, the cornerstone of whether or not such testimony would be admissible is whether or not the opposing party had fair and full opportunity to cross-examine. Here, that goes beyond saying. And not only did they get that opportunity, they had the opportunity to review the entire record of my client's testimony coming previous to that, to follow up on things. And in doing so, they actually received a great benefit at trial. Because at trial, my client originally testified his exposure to Kaiser Gypsum's joint compound was actually 5 years longer than they got him to admit when they cross-examined him later. So under the controlling precedent in this state, as long as the subject matters are nearly identical, that would alone make it enough to be admissible. Here, they're identical. There's nothing to consider here, as Justice Adams noted. I want to focus, lastly, it wasn't brought up, but I want to make, I think it's important. Justice Manzanet-Williams, or Daniels rather, you mentioned earlier today in the Rosa argument that it is not this court's role to try cases itself. You'd be out of business, I believe is what you said. And I think that a major component of this appeal is getting this court to do just that under 5501, which is to say, to take what the jury considered on pain and suffering and reduce it drastically. The McWilliams decision is again instructive on this, where this court did not touch the $23 million pain and suffering awarded to that mesothelioma for just a little, who suffered roughly a little bit longer than my own client, who suffered for 43 months. The jury here, as is evidenced by the testimony of 3 family members of Dr. Moline who reviewed the records, indicates that this was intense pain and suffering that began before he was ever diagnosed and lasted up until the moment of his death, which the jury got to consider, where they came up with their number, which should not be touched in the same manner as the McWilliams verdict should not be touched. And in doing so, they did not just consider physical pain and suffering, but the emotional pain and suffering, the pride this gentleman lost from losing his family, knowing for 3.5 years that would be the case, from, as Dr. Moline noted, even his medical records note an almost poetic description of what he was going through that she had considered very rare. My client described his initial feelings of shortness of breath as if his organs were being stretched over his skeleton. Dr. Moline described him through the medical records as having become cachectic, which means that eventually he loses so much weight so rapidly that he reduces to a skeleton, where he actually loses his muscle mass. He can't do things on his own. His family members have to help him in the bathroom. He has to take certain medications just to use the bathroom. And beginning when he was first diagnosed, first coming in for pain and shortness of breath, he notes, as is noted in the medical records, having to take 2 different types of pain medications, which is extremely rare. I bring this all up only to say that the jury had a lot to consider when they came up with this number. And just as in McWilliams, this falls squarely within the range of verdicts that this court has upheld in the past. It should not be touched here.
Counsel, what about defendants, one of the final arguments about the court having to recalculate the judgment? It seems that I believe it's the Williams case from the Court of Appeals is still the way we're supposed to calculate. It wasn't exactly calculated correctly, I think.
That is their argument, that the Williams versus Niski case should govern. However, it's the Didner case that actually addresses asbestos-related cases to determine what should come off the top under the GOL. And in this situation, where the percentages of apportionment actually came out to more than was settled for from the settling defendants, That's the number which should come off the
Was
top.
there a question about how much the settling defendants had actually paid, or was?
No, that has been disclosed, and I'll just make this final point because I believe, Justice Kapnick, you were on the panel in Adele where this same issue by this same counsel was actually rejected when they brought this up, where Didner does control, because when you look at the totality of the defendants that could have been on the verdict sheet, when you look at under the Whalen case, the fact that they all didn't end up there means that their apportionment is 0. So that's how you have to calculate it. So when you actually look to see what is greater, the percentages versus the apportionment, Didner controls. There's no reason to go to Niski. It's not an asbestos case.
So you would just have to deal with the one defendant that was on the verdict sheet, right? I mean, which
Right,
the
and
jury figure.
Correct, Your Honor. Reason being, defendant had every opportunity to try to put as many defendants on as they so chose. It just so happened in our case that only Weyerhaeuser, one defendant, ended up on the verdict sheet, and their share was greater than what they actually settled for. That's where the calculation under the GOL should come from.
Thank you.
Thank you.
If I may.
Could you address that issue? Because
Yes, I could, Your Honor. The Court of Appeals has spoken very clearly on this issue. When a settling entity pays money to settle but is not considered in the jury's apportionment of fault, that money is taken off the top before you then apply the comparison between the percentage allocated to the settling tortfeasor, here Weyerhaeuser, or the amount that they paid. And that's been established law for decades. The Didner case doesn't speak to it because Didner involved only apportionment to settling entities who did appear on the verdict sheet, which is why Whalen and Williams then had to address the question. If I could address the subject of remittitor, and I would like to address this court's recent McWilliams case. 2 principal points to make there. First, on the issue of remittitor, this court should not follow McWilliams. It's inapposite because this court's precedents establish different tolerable ranges for mesothelioma cases involving deceased plaintiffs than they do for living plaintiffs. And in deceased plaintiffs, that range of values is on the low end, the Sweber case at $3 million, and on the high end, it's the Macaluso, the Lustenring, and the Pareka cases. Now, second and more importantly,
What are those numbers?
So
roughly $4 to $4.5 million.
because they're dead, they get less? It doesn't matter how much time they suffered, what they went through, the assessment of that pain and suffering. It doesn't matter. If they're dead, their pain and suffering is worth less now? I'm asking a question.
All of those things matter, Your Honor. This court's precedents establish a lower range of values in cases where the plaintiffs are deceased. It's $3 to $4.5 million. In the cases where the analysis has been performed in living mesothelioma cases, that ranges between $5.5 to $9.5 million. $5.5 million in the Idell and the Ford cases, $9 to $9.5 million in the Miller and Robey cases. Now, I would like to make one final point about the McWilliams case. The court did not perform the 5501C analysis. What happened in that case was that the trial court held as follows: it is not the purview of the court to second-guess the jury's consideration, and given the deference that New York courts traditionally accord a jury's deliberation in a subjective analysis of pain and suffering, the court does not find a basis for remittitor in this action. And the appellate division simply upheld that without performing the legislatively mandated case comparison to its prior precedents. It did cite 2 cases. One of those was 8 times less than the $23 million sustained, and one was 6 times less. I would direct this court to its Donlin decision, which demonstrates that remittitor is an exercise that has been legislatively committed to this court, and we would ask your court to remit the verdict accordingly. Thank you.
Thank you.